Yeah, can you hear me?
Yes.
Who am I speaking with?
Good morning, everyone. Please make sure that you mute your microphones.
Good morning.
Good morning. Please make sure that you familiarize yourself enough with your device that you understand how to mute your phone or your device, and that you do so unless you are speaking on the matter that is called. Also, if you are speaking, my expectation is that your camera is going to be up and running. So if you do not know how to use that function, please make sure that you again take a look and understand how to get your video rolling. I have some other expectations as well, and that would start with the expectation that you wear clothes. I need you to have on clothes in the Zoom gallery and to be properly clothed. Inevitably, if I don't say that, there's someone that pops in the Zoom gallery without clothing. Please wear your clothes. Secondly, please refrain from the use of any profanity. Also, if you've got a device that is titled iPhone or some other generic name, please rename your device to your name so that you are readily identified. There's three little dots you can press on, and it will give you options of things you can do. One of the options is to rename your device. So right now I do see that there's an individual with a device that greeted me with a good morning, and I thank you for that. But your device is not indicating your name. So if you could please rename your device to your name, that would be most helpful to us. There's also a telephone number here. Please make sure you rename that device to your name. And I'm assuming you will be able to get video going in the event you are a defendant. When the cases are called, please make sure that prosecutor goes first, then defense counsel, then I need your client to put their own name on the record. Do not assume that I know who your client is, what they look like, if they're present, if they're in custody or out of custody. Please do provide that information. If they are not present, please then let me know if you're requesting to waive their presence. I am willing to do that, provided you have been in contact and close communication with your clients. With that being said, as soon as cases are called, we will start the process. Please be patient. If there is no opposing counsel on your matter, we will have to pass on it. It's nothing personal, but that is kind of how it goes. It's necessary to have both counsel for the defendant and the prosecution. If there's any special motion you wish to address, please make sure you're in touch with opposing counsel so no one is caught off guard.
Do I have all parties on board? Defense counsel and prosecution? Calling parties on Syed? Calling case number 2158780, the people of the state of Michigan versus Muammar Syed. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence, habitual offender, third offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P7730 on behalf of the people.
Good morning, Judge Francis Murphy, P78213 on behalf of Mr. Syed.
Okay,
Judge-
I'm sorry, before you proceed, I am going to, I need the iPhone user to rename their device. And if you find yourself in a waiting room, don't worry, we'll pull you back when we need you.
Huh?
Each,
I can't, I'm on the number.
okay, so for instance, right here, this gentleman's going to find himself in a waiting room. If this is your client, please just remind me, he does not have his device named and his microphone keeps unmuting. So he will be in the waiting room. The device titled iPhone user will also go into the waiting room. Madam Defense, on this case that was just called, Ms. Murphy, is your client present?
Judge, I don't believe so. I don't see him in the waiting room. Based on my review of the Register of Actions, it looks like he was given a personal bond with a GPS tether. I have not been in contact with him. I will be sending him a letter today. If you're willing to waive his presence and set it for exam, I would appreciate it. But I understand your policy, so.
No, I'd be willing to give you an exam date.
I will say he originally did check in with me. I'm not sure where he went, but he did.
If you are requesting to waive his presence, I will waive his presence. There were 3 people that were put into the waiting room. None of them responded to this case though, but are you requesting that I waive his presence?
Yes, Judge.
So ordered. And can we have an exam date that is, well, Mr. Bloomers, do you have concerns regarding bond?
No concerns from the people, Judge. The people are satisfied with the bond at this time.
Okay.
November 23rd at 10:30.
Yeah, that was I believe that's what we had already discussed, and that works for me.
Okay. In-person examination, November 23rd at 10:30, and the bond will continue.
Thank you, Judge.
Thank you.
Mr. Cripps, I see you're here, but I need the prosecutor, who I believe is Mr. Makepeace.
All right, I'm gonna have to leave for an exam then.
Okay.
I'll come back in a couple hours if it's possible.
Okay, that's fine.
Okay, thanks.
Calling parties on Kmac. Case number 2159776. The people of the state of versus Traymon Kmac. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. Count 3, domestic violence. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Andrew Moxie, P number 69568, standing in for Daniel Bitar.
Okay, and your client?
I saw him on Zoom.
Hello, I'm here.
Can you please state your name?
Traymon Kmac.
Thank you. Okay, counsel, what's your pleasure?
Judge, Mr. Bitar was here earlier. He's in receipt of discovery. He simply wants to set this for an exam date, and I believe the clerk has already secured one.
Okay.
November 23rd at 9:30.
Mr. Prosecutor, was there any concern regarding bond in this matter?
No concerns from the people. The people are satisfied with the bond at this time, so I think that date should work for us.
Okay, thank you. All right, was anything further, Mr. Moxie?
No.
Okay, thank you so much. So Mr. Kmac, please mark your calendar. Make sure that you plan on being here in person, not on Zoom, in person at 36 District Court.
Okay.
Also, please make sure that you continue to abide by the no contact provision. There's no contact whatsoever, not directly or indirectly with the complaining witness in this matter. That would include letters, phone, chat, text, any form of social media, or even having someone act on behalf of yourself to reach out to the complaining witness. That would be considered a violation and could have the effect of revoking your bond. You understand, sir?
Yes.
Okay. We're all set here. You can log off.
Thank you.
Do I have the parties on Clark and Christian? I saw Mr. Christian sign in, but I did not see Mr. Clark.
I'm on here.
Mr. Clark?
I don't see it. I don't see him on here right now.
I'll do Mr. Christian and then we'll just have to get the other one comes back. Is that who's your client, Mr. Strong?
Mr. Christian.
Okay, he signed on, so we'll go ahead and call him. Calling parties on Marcellus Christian, case number 2058372. The people of the state of Michigan versus Marcellus Christian. The defendant is charged with count 5, assault with a dangerous weapon, felonious assault. Count 6, weapons, felony firearm. Judge, this matter was habeas entered yesterday.
Oh, yes, okay. Appearances, please.
Good morning, Your Honor. Remax for BP 82800 on behalf of the people.
Attorney Strong, appearing on behalf of Mr. Christian, Your Honor.
Okay, and Mr. Christian.
Marcellus Christian, Your Honor.
Thank you, sir. All right, today we are addressing this matter that was set for an examination yesterday, and Mr. Christian failed to appear and a capias was entered. I know that Mr. Strong, I asked you if you were able to get in touch with your client to Zoom in.
Tayshawn.
Yes.
Tayshawn. Come here.
However, we were enthralled in another examination at the time, and I asked Mr. Strong to please come back in the morning. So thank you for returning, Mr. Strong, and thank you, Mr. Christian, for taking the time to Zoom in. We did need your presence here yesterday, but I appreciate the good faith effort in coming to the Zoom court yesterday afternoon and again this morning to get this back on track. I am going to set aside the capias if that's your desire, Mr. Strong.
It is, Your Honor.
I will set aside that capias as it relates to Mr. Christian. And I cannot recall, Ms. Yafufi, I know you were not here. Ms. Yafufi, I know you were not here on this matter, but would you know if there were witnesses that appeared in this matter?
I can try to like 3 seconds.
Could you, because I would allow, Mr. Strong, generally I would allow an individual who Zooms back in the afternoon, and now it's in the morning, to make a motion if there were no witnesses. But I cannot recall. Tammy, can you?
I don't remember. Do you remember?
They didn't specifically state,
Yeah.
Oh,
but
okay.
I don't believe that the witnesses were here, Judge.
Okay, so if, I know, are you texting Ms. Bailey?
Yes, I already did. Just waiting on a response, Your Honor.
Okay, could you give us just a moment?
Sure, Your Honor.
It may be pivotal for you and your client if there were no witnesses.
Calling parties on Brown, Jamar Brown, case number 2158231. The people of the state of Michigan versus Jamar Richard Brown. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons carrying concealed. Count 3 and 4, weapons, felony firearm. Count 5, police officer assaulting, resisting, obstructing, habitual offender. 4th offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Remax on behalf of the people.
Morning, Your Honor. Andrew Moxie, P number 69568. I'm not sure if Mr. Brown is here. I just talked to him last night by text.
Are you here, Mr. Brown?
Before you make, I got a copy of the police file.
Is Mr. Brown present? Mr. Brown? The device titled Buck Battle Battle, you need to rename your device to your name. That is why I put you in the waiting room. Is Mr. Brown present? Hearing no response, are you requesting to waive your client's presence?
Yes, Judge. He was just in front of you last Friday.
Okay. I will waive his presence. This is up to date. What's your pleasure?
Judge, he told me he wants the exam, so I'm requesting a date. And then there's also another bond issue when the court has a chance.
Okay, it looks like, is this domestic violence or no?
No, Your Honor, it's my case. The, Jamar Brown, right?
Yeah.
Correct.
SVU, felony domestic violence stamped on the front, but no, it's not. It appears to be in general warrants. I don't know if that's something you want to check on, but it is stamped on here, SVU, domestic violence. Okay, well, are there concerns regarding bond that might affect the timing of setting an exam?
Your Honor, I don't know, I haven't spoken with the complaining witness, but I think I should speak with, Mr. Bloomers on about this case, because I just saw that it is stamped SVU felony domestic violence.
Yeah, and it, just so that we're all on the same page, it's, the bond is set currently at $10,000, personal bond. There is a GPS tether with house arrest, and a no contact provision with the complaining witness. Mr. Moxie has indicated that he wants to set this for an exam. Mr. Bloomers, I'm not sure if you're hearing this conversation, but perhaps this might be one that you want to eyeball.
Yeah, I'm pulling it up right now to take a look.
Okay.
And Judge, sorry to interrupt, but he just sent me a text and said he is in the meeting room.
Oh, please state your name then. Mr. Brown, please state your name. He might be in the wrong waiting or Zoom gallery, because I don't have anybody in my waiting room.
Yeah, he knew how to find you on Friday, Judge, so I don't know.
Okay, Mr. Bloomers is taking a look at this. If you could bear with us for just a moment, just to make sure we have it in the right division.
And Judge, I don't have a problem if you just want us to come back for another PCC to whatever you want to do, Judge.
Judge, I did have a chance to look, and it was originally sent to our unit and signed by our unit, but since nothing is charged, it should DCW FI, I think.
Every third word was chopped out.
I apologize. 1 second. I had a look at it. Can you hear me now, Judge?
Yes, sir.
Better or no?
Better.
Okay. So I had a look at it, and it was signed by our unit. However, because nothing assaultive was charged, it's just an FIP, CCW, and an R&O. It was sent to general warrants because there is no assaultive component.
Okay, thank you so much. Okay, we can set this for an examination then. Let's, Madam Clerk?
I moved into January. You want me to keep it?
Yeah. So
This side?
I'd like to, but I know that's
fine.
jamming us up, but
Yeah,
yes.
no, we can do November 23rd at 11 a.m.
Does that date work for you?
I'm checking right now, Judge. November 23rd at 11.
Yes, sir.
That's perfect.
Okay, November 23rd at 11, in-person examination. And please make sure your client, since they're not present here, make sure that they understand that they should be in person, not on Zoom. That seems to be kind of a confusing aspect nowadays. People aren't sure where they're supposed to be. So in person at the courthouse, and you should continue abiding by the bond conditions, and we'll see you then.
Judge, I know we don't have him here, even though he texted, he said he's in the waiting room, but you modified the bond on Friday to allow him, and I sent an order and you signed it to allow him to go to the hospital and the doctor. This was the guy that had a gunshot wound and had a metal part in his arm being replaced. So that was granted. He's gone to the doctors. He wants to get back to work. So I'm asking for another modification of the bond, this time letting him out of the house during daylight hours. I was thinking 7 a.m. to 7 p.m. to let him return to work.
And I certainly understand that need. However, it probably is most appropriate if he's present and he can articulate the specific hours. I don't want to just blanketly give wide open hours. So if he has verified employment, if that is the case, then we should be able to nail down specifics in terms of hours. If he's seeking employment, then we will go from there and determine what time frame would be appropriate. And then once he has secured that employment, then we can further alter to fit within his work schedule.
I understand. All right. I'll be in touch with him and see what his issue was not getting in this morning.
If you need to just pop back in either today or at some future date, just give us a heads up. And, I'm pretty open door policy on that. So we can make patients so long as you give the prosecutor some heads up on the issue as well.
Okay. Thank you.
Thank you. Ms. Yakufi, off the record, did you hear a response from Ms. Bailey on the Christian matter?
I did. We can call it again.
Where are the witnesses?
No.
Oh, okay. Recalling People versus Marcellus Christian, 200-58372. Appearances again, please.
Good morning, Your Honor. Rima Yakufi on behalf of the people.
Ronnie Strong, on behalf of Mr. Christian.
Okay, and Mr. Christian, your name again?
Marcellus Christian.
Thank you. Okay, so today is not the date set for exam. It was yesterday. And the defendant had capias that was entered because he was not here. And I did not ask you, sir, why were you not present?
Because my grandma had something wrong with her hip messed up. She got a hip replacement. She was complaining about taking me yesterday.
Can you repeat that? Medical reporter did not pick up what you said.
I said my grandma, her hip messed up, and yesterday she supposed to took me, but I guess she was complaining about her hip.
Okay, just for future reference, in the event you might find yourself with a court date that you have to appear at, you need to make sure, sir, that you have a backup plan. Because what happened in your absence is that I signed an order that would have the effect of having an open warrant for you. Do you understand that?
Yes, ma'am.
So, you have to make sure going forward that if you're supposed to be somewhere, you kind of need to figure out, and I'm sorry to hear about your grandmother, but you need to figure out how to satisfy, even if you had called us, that would have been.
I was talking to y'all.
I mean in the morning when you were supposed to be here. Oh, did he call in the morning to say he had
Yeah, I
problems?
talked to y'all. I talked to my
Mr.
lawyer
Christian.
and y'all.
All right, hold on, sir. I had talked to Mr. Christian the day before, and he indicated that he had everything in place for him to be here. yesterday. When I talked to him yesterday morning, he indicated that his grandmother was having problems and he said he was gonna try to get down there. Then when I called him out in the hallway before the case was called, he indicated that he was still having transportation problems getting down here.
Okay.
So, and that's what I came in and I
Okay.
explained to the court. And then we got on Zoom right afterwards.
And then I asked you to come back this
Correct, Your Honor.
Okay, so, Mr. Christian, what happened yesterday is that it was your exam date, but the prosecutor did the prosecution have witnesses?
No, Your Honor.
The prosecution did not have witnesses, so had you been here, your attorney would have made a motion, is that correct?
That's correct, Your Honor.
And what motion would that be?
I would have moved to dismiss the case.
So I am going to grant that motion, even though it's a day late. I certainly understand the explanation you provided. And you made a good faith effort by zooming in yesterday afternoon. We just couldn't get to you. And you're back here again this morning. So I'm going to grant that motion to dismiss. It's dismissed without prejudice, though. Keep in mind that what that means when there's a dismissal without prejudice, that means that it's possible that the prosecution can reissue. I have no idea what the likelihood of that is. But I always like to explain that so people understand the language and what it means. So do you have on a GPS, please mute your microphones. Do you have on a GPS tether, Mr. Christian, that I need to remove as a result of the case?
No, ma'am, I don't have no GPS tether on.
Okay, and Madam Prosecutor, are these all felonies? Are there any misdemeanors that pertain? Looks like they're all felonies.
Your Honor, I don't have the file.
They're all felonies.
Yeah, okay.
It's a bad felony.
Okay, all of the counts that pertain to you, Mr. Christian, are dismissed without prejudice. And I'm going to ask Mr. Strong.
Excuse my phone, y'all connection had went out. Can you repeat that, please?
Yes, sir. So I'm going to dismiss all the counts as they relate to you. They're dismissed without prejudice. Mr. Strong, I'm going to ask for your signature as the moving party on this dismissal without prejudice. And if there's any further questions you have with your attorney, please make sure that you contact him and he will explain any questions that you might have in greater detail.
Okay.
Okay. And what happened to Will? Ms. Cal is here. Is Ms.
Cal is here. Mr. Clark zoomed in yesterday afternoon, but he has not zoomed back in today as far as I know.
Okay. This is for Mr. Strong.
Mr. Strong.
Okay, People versus Willie Clark. This is 200-58372. Can I have appearances? This is also a matter that was scheduled for exam yesterday. Can I have appearances, please?
Good morning, Your Honor. Read my application on behalf of the people.
Good morning, Your Honor. Wanda Kell on behalf of Mr. Clark.
Mr. Clark, are you here? Mr. Clark, are you present, sir? Madam Court Reporter told me that Mr. Clark did zoom in yesterday afternoon. Did you know why he did not make the actual court appearance?
No, I've had no contact from Mr. Clark.
Okay, did he zoom in yesterday afternoon?
Him and Mr. Pratt were both zoomed in yesterday afternoon.
Well, now who's Mr. Pratt?
Mr. Christian.
Oh, Mr. Christian,
Yes.
okay.
On there.
All right. Well, Ms. Cal, you understand what's going on here. I'm certainly, according to my recollection and Madam Clerk's recollection, your client did zoom in yesterday. Mr. Christian, was he there zoomed in too?
Yes, he was on here zoomed in with me. I sent him all the stuff.
Okay, so, and I know that he was supposed to be here in person, but I am satisfied when an individual zooms in, at the very least, to get things back on track. What is your pleasure at this time? Are you requesting to waive his presence and make a motion given the posture of the case, or what's your pleasure?
Yes, Your Honor, I'd like to waive his presence and I'd move for dismissal based upon the prosecution not having witnesses available.
Okay. It is a little concerning that he did not appear today via Zoom. However, again, I want the record to be clear that I do recall him appearing on Zoom yesterday afternoon at 1:30 when we could not get to the case. And I appreciate, again, that good faith effort to try to remedy this issue. So I am going to grant your motion for a dismissal in this matter, as the prosecutor had indicated. This is the co-defendant on People versus Christian, and the prosecutor has indicated that no witness appeared yesterday. So I'm going to grant that motion to dismiss.
Thank you, Your Honor.
You're welcome. Without prejudice, please make sure your client understands what that means.
Yes, Your Honor.
And Ms. Cal, do I have permission to sign your name to the order of dismissal as the moving party?
Yes, you do.
Thank you. We're going to forward a copy of this to you as soon as it is processed, and the prosecution will get a copy as well.
Thank you, Your Honor. Have a great day.
You too.
Bye-bye.
Calling parties on Bynum, case number 2159787. The people of the state of Michigan versus Alexander Bynum. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Kmac, moving on behalf of the people.
Good morning, James Anderson on behalf of Mr. Bynum, who is on the screen. And hopefully he can get his grandson to unmute him. He's not real tech savvy, Judge. If we can continue, I did speak with Mr. Bynum, and after discussing the case, he wants to hold his preliminary examination. Isn't that, can you unmute and state your name, Mr. Bynum?
Yes, unmute.
I think we can hear you enough.
Yes.
State your name, Mr. Bynum.
My name is Alexander Bynum.
And do you consent to have this hearing today on Zoom?
Yes.
Okay. What's your pleasure?
Judge, we want to waive our, I'm sorry, we want to hold our preliminary exam, and we'd like a date.
Zoom exam?
No, it's scheduled for a probable cause, Judge.
Oh, okay. So you want an in-person examination date?
Yes, Judge.
Okay. Any concerns with bond?
No, Your Honor.
Okay.
January 4th at 10:30.
One moment. That's good.
Okay, January 4th at 10:30. Please make sure your client understands that the expectation is that he would be here in person at the courthouse.
I will, Your Honor. Very good. I'll call you in a moment, Mr. Bynum.
Anything further, counsel?
Nothing for the defense.
Thank you. We're all set here.
Thank you. You can hang up now, Mr. Bynum.
Okay, Tasha, how you hang up?
Calling parties on Copeland, case number 2159779. The people of the state of Michigan versus Dajon Copeland. The charged with count 1, weapons carrying concealed. Count 2, weapons, firearms, possession by felon. Count 3, weapons, felony firearm. Habitual offender, third offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Kmac, moving on behalf of the people.
And good morning, Your Honor. May it please the court. Kim Michon, Neighborhood Defender Services, P59167. On behalf of Mr. Copeland, who is out on bond, he is on the call. I would ask him to unmute himself and state his name for the record.
That's Lauren Copeland.
I'm sorry, your appearance again, Madam Defense?
Kmac, Neighborhood Defender Services, Your Honor.
Okay, and Mr. Copeland, I did hear him put his name on the record. Thank you. What is your pleasure?
Your Honor, we wish an in-person preliminary examination. I've spoken with Ms. Yafufi. She is always on top of her game, and she's indicated she has sent the link for both paper and digital discovery. Prayerfully, we'll be able to download those and get them to Mr. Copeland.
Okay, in-person examination date.
January 5th at 9:30.
Lovely.
Okay, in person. Mr. Copeland, that will be in person here, not on Zoom. Please make sure that you are present and allow yourself enough time to pass through any security or health screening that might be in place.
That's 9:30 or what?
9:30.
Yes, ma'am.
Yeah. Okay, is there anything further?
No, Your Honor. Thank you so much.
Thank you. Have a good day.
And Mr. Copeland, you can hang up now.
Thank you and have a good day.
You too, dear.
Calling parties on Devold, case number 2157970. The people of the state of Michigan versus Tyrone Dimitri Devold. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, felony firearm, habitual offender, second offense notice. This is scheduled for probable cause conference.
Thank you, ma'am. Appearances, please.
Kmac on behalf of the people.
And Kmac, Neighborhood Defender Services, P59167, on behalf of Mr. Devold. Mr. Devold is out on bond, Judge. I have had contact with him. We would ask that you waive his appearance for these purposes.
So ordered. What's your pleasure, Ms. Michon?
Your Honor, we are in receipt of paper discovery, and Ms. Yafufi, once again, being on top of her game, has emailed me any additional discovery that she might have. We're requesting an in-person preliminary examination date.
Judge,
yes.
January 5th at 10 a.m.
Perfect. I just happened to be there.
Perfect. That will be an in-person examination. Please make sure your client understands that. And is there anything further?
No, Your Honor. Thank you so very much.
You too. Take care.
And a lovely day to you and your staff. Please, everybody, be safe.
Yes, you too.
So we don't know who is standing in for Mr.
I'm standing in for BCCs, but that's about it. I believe it's Melvin Cook for exams.
Okay, all right, because the first one up is his. When after I call this case, I'm gonna text, see if I still have Mr. Cook's number. Okay. Calling parties on Battle, case number 2056264. The people of the state of Michigan versus Charlie Battle. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, motor vehicle, unlawful driving away. Habitual offender, third offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Fufi on behalf of the people standing in for APA Jacob Slusky.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Charlie Battle.
Mr. Battle, please state your name.
I'm Charlie Battle.
Thank you. Madam Defense, good morning to you, and what's your pleasure?
Your Honor, when I appeared the last time, I asked for an opportunity to get discovery, but I didn't get it yet. I've searched to see if anything came in on this case. I have other things coming in from evidence.com, but not this case. And I just sent an email to, not an email, a text in the chat to Attorney Yafufi to see whether or not she was handling it. She indicated it's a different lawyer. I think she said Melvin Cook.
Oh, Marvin Cook.
He's just standing in for Mr. Slusky.
Okay, so it's a problem, however, that you don't have discovery. That's a little frustrating. So what would you like to do here?
I'll ask for another date, but I don't know who is handling it. She said she was standing in for somebody else just now.
Yeah, so if this is a Pat 2 case, Mr. Slusky, yes, it is. Mr. Slusky is on holiday. He has someone standing in for him that's kind of rotating. Right now, Ms. Yafufi is standing in on PCCs. But I don't know that she can speak with regards to discovery being sent. Can you?
I can't, Your Honor.
What I'd like to do, when is Mr. Slusky due back? The week of the 16th?
I believe so.
I think so. I'd like to set this for another PCC, considering the fact that your client is not in custody. I want to make sure that you have an opportunity to review the discovery and to review it with your client so that you know how you wish to proceed. Are you available to zoom in on either the 16th or the 17th for another PCC so you can get that discovery?
Split second, Judge.
Or one day that week even?
I'm available by Zoom on the 19th. The others, I have a bunch of in-persons, so on the August 19th, I'm available.
Sounds good. August 19th at 8:30 via Zoom. And if you put Ms. Yafufi, make sure that a notation is sent to Mr. Slusky's email such that when he sees it, he can forward that discovery in advance of that date.
It's been sent, Your Honor.
Thank you so much.
How do you spell his name? His last name, Slusky?
S-L-U-S-K-Y? I don't know.
Yes, correct. S-L-U-S-K-Y.
Is it a J in front of it, like as in Jacob?
Yes.
Okay. Thank you.
Thank you.
All right, Mr. Battle, I'll be talking to you when we get off this Zoom. I know, did you get my text just now? So I know I have the right
Yes.
number? Okay.
Yes.
Thank you, Judge. Thank you, staff.
Welcome.
Have a good day.
Same to you.
They don't know who's coming in, what he is it the other Jacob? And Cook. Oh, good. Okay, I think he's upstairs.
Mr. Cook is?
Yeah, I saw him upstairs. He checked in and then he left. I saw
Oh,
him.
he did check in. Okay, I was sending him an email. I didn't know he even checked in. Okay, I'll just wait then if he's in the building.
I mean, he didn't come any further than the hallway though.
But he checked in on, he knows he has a case in here.
Yes, ma'am.
Okay. All right, I don't have anything else to tell. All right, what were you telling me, officer? Keys and Roby?
Keith is gonna be probably at Adjournment.
Okay.
He's still in custody.
So he's not here.
Right. Which is.
Yeah.
And, Roby, prosecutor.
Okay.
He's not here.
Let me know when you want to bring Miss Long Street in.
I know,
Okay.
I'm trying right now. And Judge, it looks like, the matter scheduled for 1:30, Mr. Rivera is not gonna go because they didn't transport him. He was at Wayne County Jail, and since the last date, they transported him back out to Jackson and didn't bring him back. So I don't believe that's gonna be able to go today. I haven't had a chance to, we were just trying to figure out.
That's probably a general warrant, I think.
I think it's Ms. Shafuti. I was actually gonna, I don't know if Mr. Gordos is back or not. I haven't seen him.
Was he on holiday?
Someone checked in. I have this, like a check that someone checked in for him. So I'm not sure if he's up there or not.
I do not have, all I have right now is Attorney Glenn, court reporter, yourself in the courtroom.
Okay, maybe, okay, no problem.
Let me make sure no one else is in the waiting room. Someone checked in for him?
Maybe I just checked, it's the same check I usually do when someone checks in, but maybe, I think I did it when the officer told me that it was gonna be an adjournment, so.
Okay, so he is, if you could tell me again what is going on with him?
So Judge, his sister informed me that he was in the Michigan Department of Corrections. I looked him up on Otis. Otis said he had a supervision discharge date of 7/30/2021, which didn't make sense. But then I called this morning, Gus Harrison Correctional Facility, spoke to someone in the warden's office, and they confirmed that he is there.
And where is that again?
Gus Harrison Correctional Facility. GUS, the common spelling.
Okay. And is that information that we did not have before, obviously, which would explain why he was not written out to be here?
Right, we didn't have that information.
Okay. That sounds like it necessitates an adjournment. Don't know, what is the turnaround time? How soon can we set it? Is it 10 days?
I believe it's 14 days.
Okay, for it to be processed. So some date after 14 days, if you could look at your calendar and see when you would like to reschedule this.
And Judge, maybe I will tell the court that the complainant in this case was also on parole, so I don't know if the prosecutors made contact, but before we.
Yeah, is there a witness that appeared?
There is no witness, Your Honor.
Oh, okay, well, given the fact that the reason that the defendant is not here is because he was not writted to be here, thus, by no fault of his own, he's sitting in custody at the location you just mentioned. Is there a motion you'd like to make? Because I'm going to assume that not only are the witnesses as represented by the prosecution not here, but that they were also notified to be here.
They were notified, Your Honor.
Okay. Yes, Judge, and I would make a motion to dismiss and just tell the court that in the discovery, it does say that both these individuals were residing together and they both were on parole. And so the complainant doesn't appear to be here. So I'll make a motion to dismiss.
There is a witness here too.
Oh, they're here?
There is one.
Not on home.
Can you, on keys, can you check this to see
Yeah.
if that's your necessary witness? Yeah.
Mr. Glenn, I have you checked in on Hassan Turner. What did you want to do this morning?
I just set it for an exam. I'm going to write a gun board letter.
Okay, January 5th at 10 a.m.
January the 5th?
Clear your schedule.
No, I'm just teasing. I'm like, okay, January the 5th at, yes, I'm available.
At 10 a.m.
At 10 a.m. Okay, thank you very much.
All right.
Okay, so we don't have to go on the record. My client's in the waiting room.
You're all set. Let's see.
Well, I don't think I have anyone in the waiting room, but no, we don't need to go on the record unless you would like to.
Oh, no, I wouldn't. My client said he was in the waiting room. That's why I said that. So, okay. But
He may have been in the waiting room earlier, but no one's in there now.
okay, I'll call him and let him know. Okay, thank you very much.
Oh, okay, we are back on the record in the matter of People versus Kenneth Keys, 2006238. Ms. Yafufi, do you have a witness in this matter?
We do, Your Honor, and he's currently in the courtroom.
Okay, thank you. So what has happened, sir, is that, could you state your name?
Yes. Yes, my name is Bruce Tony.
Okay, Mr. Tony, what has happened is that with today being the exam date, it has been brought to the court's attention that the defendant is at Gus Harrison Correctional Facility and was not writted out from that location because no one knew that he was at that location. That information just came to be known. I'm not certain where was he in a facility before and we just didn't know he was transferred to this one, or he was out on bond?
I believe he was out on bond, and then as a result of this case, his parole got revoked and he was taken into custody.
Okay, so there was a gap in communication, if you will. So because the writ was not processed, that is why he was not transported. So he's not physically here, nor is he in the Zoom gallery. So that puts us in a position of needing to reschedule this. So that is why I'm glad that you came into the courtroom, because we want to make sure that the date that this gets rescheduled to is a date that also works for your calendar. We were discussing that, Madam Defense. What date after 14 days might work for you?
Maybe the September 1st, probably? And Judge, what I may suggest is that, given the fact that the claims here, I know the discovery and evidence in the case, it might be a good idea to set this for PCC, and then I will schedule a video visit with him and see if we can resolve it before bringing him.
Okay, all right, so let's do that. Do you want to do that within 1 week or 2 weeks?
I think I can get it my visit with him scheduled within 2 weeks.
Okay, so today being the 5th, how about August 19th or the 20th?
The 20th will work.
All right, new PCC. So Mr. Tony, to be clear, we don't need you on this next date.
Okay.
You're welcome to appear in Zoom, but it's going to be by way of Zoom on August 20th at 8:30, again via Zoom. That way, Madam Defense, you'll have an opportunity to set up a time to speak with your client in the interim and determine whether or not you are proceeding to an actual exam or waiving the exam. So if you have questions, Mr. Tony, regarding what's going on here, please make sure you take a moment to speak with the prosecutor here.
Okay.
And she will answer any questions that you might have, okay?
Okay.
All right, we are all set. Thank you so much. Oh, Madam Prosecutor, I do want to make sure that there's a notation made that there will need to be a Zoom writ.
Right. I got that.
Process for him to be present on August 20th.
Got it, Your Honor.
Okay, so, I gotta have some type of paper.
No, you're right. No, I'm not.
Calling parties on Holmes, case number 2062025, the people of the state of Michigan versus Diablo Holmes. The defendant is charged with count 1, weapons, firearms, possession by felon, count 2, weapons carrying concealed, count 3, weapons, felony firearm, habitual offender, second offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Remind me on behalf of the people.
Kristen Longstreet from the Neighborhood Defender Service, appearing on behalf of Mr. Holmes. But Mr. Holmes is not present.
Okay. Oh, I'm sorry. Is this Mr. Holmes?
I think they brought someone else.
Oh, okay. All right, and he's not here? Why is he not here?
Judge, I made attempts to contact him, his number is disconnected, I sent the email, that bounced back.
Okay, have you had any contact with him at all from the inception of this?
Yes.
Okay, but at some point you lost contact with him?
Yes.
Okay. Well, today is the date and time for the big event, and he has failed to appear. This matter was set for 9:30 in the morning. It is currently 10:04, and no explanation has been provided that might explain where Mr. Holmes is. So is there a motion?
Your Honor, people move for capias.
Habeas is going to issue, previous bond is going to be revoked. New bond is going to be set at $10,000 cash or surety. And we're all set here.
Thank you, Judge.
Thank you. Good to see you.
Good to be back.
Oh, you know what? I'll tell you that.
Oh. Are the copies here on the
He's right there.
Oh, does he? Okay, never mind. Disagree.
Or on Young?
I'm jumping.
Yeah, he's in custody.
Right. I just want to make sure, is this gonna be a hold?
No, this is a dismissal.
Okay.
Yeah.
Because otherwise, we're gonna need to do the other one first.
Yeah.
Calling parties on Roby, case number 1661663. The people of the state of Michigan versus Preston Eric Roby. The defendant is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance, possession with intent to deliver on school or library property, narcotic or cocaine less than 50 grams. Count 3, weapons, felony firearm. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Remind on behalf of the people.
And good morning, Your Honor, from Neighborhood Defender Service, Jonathan Hortis, P7893, on behalf of Mr. Preston Roby, standing behind me to my right. Mr. Roby, can you state your name?
Preston Roby.
Thank you. Today is the date and time set for an examination. It's set for 10 a.m. It's currently 10:06 by the court's clock. Are we proceeding to an exam today?
Your Honor, at this time, the people are not ready to proceed. The complaining witnesses here, which are all police officers, have been notified and subpoenaed to show up to court and none have done so.
Move for dismissal, Judge.
Matter's going to be dismissed without prejudice. Mr. Portos, I do need your signature on this as the moving party. And once we get that, we'll be all set. You can have a seat in the hallway, Mr. Roby.
Thank you, Judge.
Thank
You
you.
can walk free, Mr. Young. Is his attorney in the hallway?
Attorney was down there talking to him.
Oh, okay, okay. And Miss Yafuki, if you let him know what's going on with the 130. Right, he's not here. Mr. Rivera.
I talked to you many times.
assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Yafufi on behalf of the people.
And good morning, Your Honor. May it please the court, Deanna Belcher, P80177 on behalf of Mr. Young. Mr. Young, can you please state your name for the court, nice and loud?
Daniel Young.
Thank you. Today's date and time set for an examination. What's your pleasure?
Your Honor, at this time, the people are not ready to proceed. Complaining witness Tony Young has been subpoenaed and notified to show up to court and has not done so.
Defense is moved for dismissal, Your Honor.
Okay. It is currently 10:17 in the morning. This matter was set for an examination at 10 o'clock. And with the representation that has been made by the prosecutor, I am going to grant that motion for a dismissal. The matter is dismissed without prejudice. I do need your signature, Madam Defense, on the order of dismissal as the moving party.
Of course.
And we'll be all set.
Thank you so much, Your Honor.
Thank you.
I'm gonna take it down.
You got the dismissal. Yeah. All right.
Ms. Belcher?
Yes.
Thank you. Thank you so much.
Do you have witnesses on the Collins that you anticipate coming?
Collins, I don't know, I feel it's not, but I don't know if they're coming or not. I've been
Judge Archibald and Tammy. Okay. How old is she? Oh, I mean, unless she's like underage, then yeah, she should. Okay, all right.
What kind of,
Okay, all right.
what was gonna ask, if they're asking to bring somebody in with a witness?
Yeah,
Was it like a?
it was her.
Mr. Cordes?
Oh, yes, Judge. Sorry, I didn't want to interrupt. I was circling back with you about Rivera. He was indeed released on personal bond. My notes show that it was a $50,000 personal bond with a tether. He is not in the jail, so everything should be groovy for 1/3.
Thank you.
Thank you.
Yep, no problem. We'll see you then.
Take care.
Hey there. Is there anything we can do? It's like we're just wasting time sitting here. What you got? For this one?
Can't locate.
You know, it might have gotten moved in. Let me see.
Yes, ma'am.
Oh, you know what? That's scheduled for rain. Downstairs on the Escher check. 18:30. Yep. Marvin could have been up there standing in for Mr. Preston. Okay, all right, thank you. All right. Hey, honey, it's Tammy. Hey, has Marvin been up there standing in for Mr. Schleswig? Okay. Oh, okay. All right, thank you. All right.
Do we have any attorneys out there? Officers? Officers, do we have any attorneys out there?
Still missing the nine house on Hubbard.
All right, thanks.
Mr.
All right,
Dochi is out here.
Is there anything I can stand in for 9 minutes now? Is it for exam or?
No, what he's here for.
Who is that?
I want to give you that file, it's a waiver. Good.
For Goodman?
Are you on the nails matter?
No.
That was Tammy talking.
Oh.
I'm looking for the file. I was actually trying to track down Mr. Cook. I don't know where he's at.
Well, Marvin, well, yeah. You know, when you're saying Mr. Cook, I couldn't think who you're talking
Yeah,
about first.
he's standing in for Mr. Slusky, but I just saw the 3 other felony courtrooms
There he
and
is.
he's not there.
No, it's upstairs with him. No,
Oh,
he's diligent, Marvin. Cook.
there he is.
This morning, I'm at ping pong ball, they bring.
I guess. I don't know where all these attorneys are at, especially when you've got in custody matters. Calling parties on Goodman. Case number 2060322, the people of the state of Michigan versus Donovan Craig Goodman. The defendant is charged with count 1, stolen property, receiving and concealing $1,000 or more but less than $20,000. Count 2, attempted peace officer, disarming firearm. Count 3, police officer, assaulting, resisting, obstructing, causing injury. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Judge. Marvin Cook, P55351, appearing on behalf of the people.
For Your Honor, William Winters, P35975, on behalf of Mr. Goodman, who's present in court, Your Honor.
Okay, please state your name.
Donovan Goodman, Your Honor.
Thank you. All right, today being the date and time set for preliminary examination, are we proceeding to an exam?
Your Honor, Mr. Goodman is prepared at this time to waive his statutory right to have preliminary examination. He understands that by waiving his exam, he'll be bound over to circuit court. He's ready to sign the form, Your Honor, indicating the voluntariness of his waiver.
Is there any objections from the prosecution regarding the proposed waiver?
No objection, Judge.
Okay, so Mr. Goodman, you understand the allegations against you?
Yes, Your Honor.
Do you understand that you have a right to a preliminary examination?
Yes, Your Honor.
Do you understand that if an exam did occur, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes? Do you understand that?
Yes, Your Honor.
And if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process?
Yes, Your Honor.
So the representation that's been made here by your attorney is that you wish to waive, to give up your right to a preliminary examination. Is that what you wish to do, sir?
Yes, Your Honor.
Do you understand that that would mean that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination at this phase?
Yes, Your Honor.
And is that still how you wish to proceed?
Yes, Your Honor.
Okay. Are you doing so voluntarily, sir?
Yes, Your Honor.
I do find your waiver to be knowingly and voluntarily given. The matter will be bound over to the circuit court for further proceedings with an AOI date of August 26th. One last thing that I do need, Mr. Winters, is your signature on this examination waiver form alongside your client's so that we can process the waiver.
And if we can only take up one other matter before we close the record, Your Honor.
Sure.
Mr. Goodman rather, has been on electronic monitoring since February of this year. Now, we're aware of the severity of the charges here, there's no doubt about that. But I commend Mr. Goodman for what he's done. He's facing his issues. And I think in a really positive way. He's a high school graduate, very little criminal record at all. And this seems to be a medical issue that Mr. Goodman has gone out of his way to resolve. So the court was kind enough to cut the tether hours down to allow him to work. He works out in Livonia at a pallet plant on near Plymouth and Maryland, near my office, matter of fact. He keeps in constant contact with me. He's not a flight risk. He's not a danger. I respectfully ask the court to consider removing the tether.
Mr. Cook?
Your Honor, I'd like to at least see a DSU report before.
Well, there won't be a DSU report because he's not in custody. Certainly, the fact that this has now been bound over is the only new aspect that has happened in this file. I've got to have a basis for which to make such an amendment like removal of the tether requirement. And certainly, I do appreciate what your attorney has indicated with regards to your compliance thus far and what you've been able to accomplish. However, unless the prosecutor is going to co-sign on that, I'm not comfortable with removing the tether right now. So,
We understand, Your Honor.
that is certainly an argument that can be made before the arraigning judge on August 26th, when you appear before that judge. How long has he been on tether?
January.
Oh, since January? And so the way it's set up now, I did amend it so that you could have hours, correct?
Yes.
6 a.m. to 6:30 p.m. And doctor appointments. So are you seeking, did you want an alteration of the hours or?
No, I'm sorry to interrupt. The court was considerate enough to amend the hours previously.
Okay.
We were just asking the court to remove it entirely as being not only a physical, but an economic burden.
Yeah, okay, all right.
But we understand the court's position as well as Mr. Cook's position.
But without the prosecutor co-signing on it, I'm not
Understood.
comfortable with removing it. All right, I'm gonna hand that back.
Thank you.
Thank you, Judge.
Thank you. Okay, you can wait in the hallway.
Okay. Thank you very much, Your Honor. Thank you, Tammy.
Yes, have a good day.
I'm sorry, Mr. Winter, hold on one second, can I see that one? Mr. Copley?
Is Mr. Cookley, can you
I'll
see
meet you
if he's
on
still in the hallway?
Right.
Oh, sorry.
I'm sorry, Mr. Winters and Mr. Cook, could you approach? And I just didn't want your client to go too far, I may recall it. If you could approach. This is Hubbard right here.
Yeah, Hubbard's in custody.
Oh, that's right. Shouldn't you be doing something else important?
I was.
I know.
Calling parties on Nails and Hubbard.
That's Mr. Bloomer's.
Okay, that's why I'm stopped. I'm just waiting to make sure I've got all the players. Calling case number 2156182, the people of the state of Michigan versus Davion Romel Nails. Defendant number 1 is charged with count 1, weapons, firearms, discharge, enter at a building. Count 2, weapons, firearms, discharge from vehicle. Count 3, malicious destruction of building, $1,000 or more, but less than $20,000. Count 4, weapons, firearms, possession by felon. Count 5, 6, and 7, weapons, felony, firearm. Count 8, weapons, felony, firearm, habitual offender, second offense notice. Defendant number 2, Eugene Meredith Hubbard, is charged with count 1, weapons, firearms, discharge, enter at a building. Count 2, weapons, firearms, discharge from vehicle. Count 3, malicious destruction of building, $1,000 or more, but less than $20,000. Count 5, 6, 7, weapons, felony, firearm. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Blewers on behalf of the people.
Robert Jersey on behalf of Damian Nails, P33195.
Patrick Nice, P76343, on behalf of Mr. Eugene Hubbard, who's present in court today, Judge.
Okay, please state your name, Mr. Hubbard.
Eugene Hubbard.
Thank you.
Mr. Nails is in front.
Davion Nails.
Okay, could you put your appearance on again?
Robert Jersey, P33195.
Thank you. All right, we are here for preliminary examination. Are we proceeding to an exam?
Your Honor, this time the complaining witnesses, Alexis Tankley and Trevine Haley, are not present in the courthouse. They were scheduled to be here for a 10:30 a.m. preliminary exam. Without their presence and participation, people are unable to move forward at this time.
Is there a motion?
Judge, there's a motion to dismiss from the defense.
Motion to dismiss from Mr. Nails as well, Your Honor.
Okay. It is currently 10:44. These matters were scheduled for an examination at 10:30. And with those representations that have been made by the prosecutor, I am going to grant the motions to dismiss with regards to the allegations against Mr. Hubbard as well as Mr. Nails. I will need signatures from both defense attorneys with regards to the order of dismissal. Keep in mind that Mr. Hubbard and Mr. Nails, that these matters are dismissed, but they're dismissed without prejudice. So what that trailer language after the word dismissal means is that it is possible that the prosecution may reissue in this matter. That may sound a little confusing. If it does, if you're not familiar with that concept, please make sure that you are speaking to your attorneys so that you understand the fullness of that concept. With that being said, though, I think we're all set. I will ask again that you stay, defense attorneys, that you stay for your signature to be placed on the orders of dismissal.
Of course, Judge.
I would also ask that Mr. Nails is on a tether, asks that the tether be released.
So ordered. We will notify the tether unit from our angle, and you will also get a copy, counsel, as well as Mr. Nails, reflecting that added language on the order of dismissal. It's a good idea, Mr. Nails, for you to take that to the tether unit, so there's no confusion about whether or not to remove the tether, okay? You understand? I need an audible response.
Yes, ma'am.
Thank you. We're all set. You too, sir.
You too.
Come on,
You can get the attorney on Popper come in.
okay.
Yeah, I'm okay. They gotta hear something.
I know. I'm give you all the credit.
Yeah, for just 2 minutes.
This is for your signature, sir. Hey. Oh, okay.
Yeah.
Can I speak with him?
Yeah.
Just a second, I'll get you a copy of this.
Actually understand them with the phone down there, we were having to put the masks.
Yeah, hard.
Oh, thank you. Thank you very much.
Yeah, in just a second.
No rush.
I'm gonna put you on hold for just a minute.
On behalf of the people.
May it please the court, Neighborhood Defender Service of Detroit, by Jeffrey connecting behalf of Mr. Falkert, P64800.
Thank you. Please state your name, sir.
Right, Dave Popper.
Thank you. Any preliminary matters?
None from the people, Judge.
I would just ask for an order of sequestration. I don't know if there's an officer in charge. I have no objection to that person remaining in the courtroom.
Sequestration will be granted. The courtroom is already in compliance with sequestration as we are still complying with COVID restrictions. So there are no spectators in the courtroom. The Zoom gallery is also very restricted right now. It's just the courtroom, the court reporter, the clerk, and a prosecutor that are present. And the third tier to sequestration is that this is live streaming on YouTube. So if there's anyone watching the live stream, shouldn't be watching it because you're either a witness or a potential witness. Now would be the time to refrain from watching any further to maintain the integrity of this process. Anything further?
Nothing from the people.
No, Your Honor, thank you.
Thank you. First witness.
Your Honor, the people called Jasmine Harris was there.
Good morning to you. Good morning. Could you please state your full name?
Jasmine Monique Harris.
Say again.
Jasmine Monique Harris.
Thank you. And could you spell your first and last name?
J-A-Z as in zebra, M-I-N. Last name is H as in Henry, A-R-R-I-S as in Sam.
Thank you. Could you please raise your right hand? Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but truth? Thank you. You can make your way over here to the witness chair. There's a little half gate that will open up towards you. Watch your step. And once you settle, you may proceed. Mr. Crawford.
Good morning, Ms. Harris. Could you please state your full name for the record?
Jasmine Monique Harris.
And Ms. Harris, on or about the
Please keep
date.
your mask. Please keep it up. Yeah. Do you need a paper mask?
Yeah, please, I'll get it.
We keep some extras for that very reason.
Thank you.
Oh, well, that one's pretty.
We'll start over. Ms. Harris, on or about the date of June 28, 2021, were you at the location of 12610 Lang Street?
Yeah.
And is that in the city of Detroit?
That is.
Okay. And how do you know that address?
That's the family home.
Okay. Were you living there at that time?
Yes.
Okay. And on that date, when you were at that address, were you there with anyone else or were you by yourself?
I was there with the defendant.
Okay, and you said the defendant, is that Clay Poppert?
That is correct.
And do you see Mr. Poppert here in the courtroom today?
I do.
Could you please point him so the judge can see and just state what he's wearing?
He's behind her, that officer, can't see all the way.
Okay, could you just describe an item of clothing he's wearing?
He's wearing green.
Okay. Let the record reflect the witness identified the person of the defendant.
The record will reflect identification of the defendant.
Okay, so Ms. Harris, you stated that Mr. Poppert was there with you. How do you know Mr. Poppert?
I had been dating Mr. Poppert for a year at the time.
Okay. And were you, was it a sexual relationship? So, is there something that happened out of the ordinary on that date, that brings you here today?
Yes, around 9, or I'm sorry, did you want me to go into detail?
Well, I think just in the briefest possible, just in one sentence, what brings you here today?
Yes, I was assaulted by the defendant, Mr. Harper.
Okay. So, about what time of day was this?
This was about 9:30 in the morning.
Okay. And, what were you doing before the assault began?
Before 9:30, I had drifted off to sleep. There had been a lot of things going on. Some things
Okay,
I'm
so
not sure if I can speak on.
well, that's okay. So where were you sleeping?
I was downstairs in the living room on the sofa.
Okay, so you were asleep on the sofa in the living room.
Yes.
So what happened next?
I was woken up with Mr. Harper trying to enforce himself into my mouth.
Okay.
While I was sleeping.
Okay, so you wake up and there's Mr. Popper. Where is he in relation to you?
At this time, we were nothing because of.
Oh no, I don't. No, I'm sorry. Physically, when you wake up, you said I'm trying to get you to describe, what you're saying happened.
Oh, I'm sorry.
So where is he physically when you wake up?
He was standing up in front of me.
Okay. And what was he doing?
He had his penis in his hand and he was trying to force his penis into my mouth.
Okay. Do you recall if his penis was erect or not?
I don't recall.
Okay. Did his penis enter your mouth?
It did not. He tried, but I wouldn't allow.
Okay. Did it touch your face?
It did.
Did it go at all between your lips?
Oh yeah, it did.
Okay. So it did go between your lips?
Yes.
Okay. And how many times did that happen?
I want to say 5 times.
Okay.
Like he tried to shove it in about 5 times.
All right. And would you say and on each of those times, are you saying it went between your lips?
Yeah, it wouldn't go past my teeth because my mouth was really dry and I would sleep with my mouth open.
Okay. So after those 5 attempts, what happened next?
Then he stopped trying to force him in my mouth, and then he proceeded to aggressively take my clothes off, the gray dress that I had on.
Okay. And so you testified already that he had his penis out. Was he clothed or unclothed at the time?
He was clothed.
Okay. So you said trying to take your clothes off. Did he take your clothes off?
Yes, he was able to get my dress over my head.
Okay. And what happened next? After you pulled your dress off?
I can't really recall exactly what happened next. I did inform him that I was currently on my menstrual cycle and that I didn't want to do it, and I kept saying no. And I was unable to fight him off. I really just wanted to take the tampon out at least if he was going to be aggressive, but I wasn't able to do so.
Okay. Do you recall if you were wearing underwear at the time?
I was wearing underwear, but I don't know if I don't remember if I was able to turn it in or not.
Okay. Do you recall, and so I understand that you're having a little bit of trouble remembering, this is a traumatic event to recall. Do you recall whether you spoke with the police about this incident?
Initially, I spoke with my mom about it because I didn't know that it was still considered a sexual assault because of the terms of being in a relationship or domestic relationship.
Okay. So, were you eventually interviewed by the police?
I was.
Okay. And do you recall if you gave a written statement to the police?
I didn't do a written statement, but I recited the story over 60 times that day.
Well, do you recall a written statement was made
yes.
that you put a signature to?
Yes.
Okay. Would you recognize that statement if you saw it?
Yeah.
Do you think that that statement was that made closer in time to the incident than today?
The statement? was
Yeah.
made after he was arrested by the special victim officer.
Okay, and did that happen closer to when the assault happened than now?
Yes.
Okay, so do you think that taking a look at that written statement would refresh your memory at all about what happened? Okay. I got it. May I approach your honor?
Yes.
And once you've had a chance to read it, just set it down, face down, and look up, okay?
Could we get to the record, if he seemed to direct the witness to a specific passage within the statement so that we can all know what we're looking at?
That would be the top half of the second page.
If you would just take a moment and read through it, and then once you've read through it.
The whole thing.
Yes, I would like for you to read the whole thing and then put it down, and then you'll ask the new question.
Did that refresh your memory at all as to the events?
Yes.
And so I would ask, as I asked before, and you told me you didn't remember before, do you recall whether he did put his penis into your vagina?
Yes.
And did he?
Yes.
Okay, and did you tell the police that when you gave the statement?
I did.
Okay. So after that, and how many times did he insert his penis into your vagina?
I'm not sure about how many times, but it lasted for 2 minutes.
Okay, but it's fair to say at least once?
Yeah.
Okay. So what happened after, do you recall if he, did he thrust more than once?
He thrusted probably 10 times.
Okay. And do you recall if he ejaculated?
He did not ejaculate.
Okay. So what happened after that part of the assault took place?
He just went directly upstairs, and the virtual reality game is what he was obsessed with, and he just.
Wait, I'm sorry, could you repeat that answer? I couldn't really.
I said he went directly upstairs, and he got on the virtual reality game system to watch porn and get off.
Okay. And when he did that, what did you do?
I took a shower.
Okay.
And I called my mom.
Okay. And did you eventually report this to the police? I think we already covered that.
I did, yeah.
Yes. Okay. So I'll clarify. You know, you stated that you'd been in a dating relationship. On this date, were you two sexually active as a couple?
No.
No. When had you stopped being sexually active as a couple?
2 weeks. Well, it was more than 2 weeks prior because he was arrested.
Okay.
And custody for.
Okay. Well, yeah. Okay. All right, Your Honor, I have no more questions at this time. However, the people are going to move to add an additional 4 counts of CSC third-degree force or coercion, penis to mouth, based on the testimony that was given.
So noted.
Ms. Harris, if I ask a question and you don't understand, just let me know, okay? Okay. Ms. Harris, you indicated that, and the prosecutor talked to you about your written statement being closer in time to the events, correct?
That's correct.
And that you used that to refresh your recollection on the events, fair to say? Did you tell the police that he tried to put his penis in your mouth 5 times?
I did not.
Did you forget when you gave the statement?
I did not forget.
Okay. Now, you indicated that after that, he took your dress off, correct?
That's correct.
You were laying on the couch, is that right?
That's correct.
Did he stand you up to take your dress off?
I sat up.
So you sat up and then he took your dress off while you were sitting up?
I did. That's correct.
After all of this, did you go to the hospital?
I did.
When did you go?
I went later on that day when my mom came from work.
How long after?
I want to say about 16.
Okay, so
It was some
several hours later.
Several hours later.
Okay, and in between that time, from the events at your home until you went to the hospital, you took a shower and then you left the house, correct?
That's correct.
Okay. Did you go anywhere else that day? Did you do anything?
I did not.
Okay. Did you go to your mom's?
No.
Now, you indicated that when he was trying to put his penis in your mouth, that it wouldn't get past your lips, right?
That's correct.
You would not let it in your mouth.
No.
So it didn't penetrate into your mouth.
It didn't. It just got to my teeth.
Okay, just.
So it would pass my lips and
So
slide my
got
mouth
your,
to my teeth.
I'm sorry, let's slow down a second. So he tried to put his penis into your mouth and you kept your mouth closed, correct?
Yes.
Okay. And he was pushing on your lips, correct?
Pushing, yes.
But didn't get into your mouth. You would not let him into your mouth, correct? You kept your mouth closed, your teeth closed, and everything closed, okay.
Well, I think it's important to note that on direct examination, her testimony was, it went past her lips, but she said it did not go past her teeth. So I just wanted, I don't know if we're on the same page in terms of what the direct testimony was.
And that's fine, but her testimony in response to my questions does seem to be different. And that's fine. Now, before he put his penis into your vagina, did he take his pants off?
I don't remember.
Now, you said after the events, he went back upstairs, correct?
That's correct.
Now, then you said you went and took a shower.
Yes.
Okay. Is the shower on the second floor?
It's on the living room floor.
Okay. Did you pack any bags? Anything to take with you?
To take a shower?
After you left, after the shower. I'm sorry, I'm moving ahead. So you took the shower and then you left, correct?
I took the shower and then I proceeded to go about my day in the house.
Okay.
I didn't leave after the event.
Okay. When did you leave?
I didn't leave until after he assaulted me and threatened me in my puppy.
What time is that? What time did you leave?
This is around 12:30.
About 12:30?
Yes.
Okay. And when you left at 12:30, did you go to your mom's?
No, I just pulled off while I was calling the police.
Okay. So after he had tried to put his penis in your mouth and then put his penis in your vagina and assaulted you, you stayed at the home for about 3 hours.
I did.
Okay. And then it was after that you left, correct? And called the police?
After he assaulted me, yes.
Right, and when you left is when you called, when you were leaving, so you called the police,
That's
correct? Okay. And you indicated that it was about 2 weeks prior to this was the last time that you and Mr. Popper had sex, correct?
It was more than 2 weeks, but I'm just gonna say 2 weeks.
Okay. I have one moment here.
Yes.
Nothing further.
Any redirect?
Just briefly, Judge. So going back to the first part of the assault, my understanding of the direct testimony was that you testified that when he tried to put his penis in your mouth, that it went past your lips, but your teeth stopped.
That's correct.
Is that an accurate description of what happened? Is that an accurate description of what happened?
That is correct.
Okay, and you testified that happened at least 5 times.
Yes.
Is that accurate?
Yes.
And the penis, did it go past the lips to the teeth on all of those 5 occasions?
That's correct.
Okay. No more questions.
Nothing further.
Okay, thank you. You may exit the courtroom. Any further witnesses for the prosecution?
No further witnesses, Your Honor.
No witnesses here.
Is there a motion?
Yes, Your Honor. The people would move to bind over on all charges, including the additional 4 counts of CSC 33.
Mr. Kenneth?
And we'd object to the bind over, specifically with the inconsistent testimony on the complaining witness about the 5 times. I think at best they can make out is 1 count of CSC 3rd degree for the vaginal, and then based on her inconsistencies and her testimony, that first count should fall along with the additional counts that they're requesting be added. And just for, I know it's not required, but a little notice on the addition of multiple criminal sexual conduct charges would be nice to know ahead of time so that I can discuss that issue with my client.
Certainly, in a perfect world, it would be. And there are certainly circumstances that arise, such as prosecutor just being made aware of certain things that might prompt an addition of counts. And if it's made out in the proofs, the court does certainly consider it. And Mr. Bloomers did give the courtesy of mentioning that prior to the commencement of the examination, although I understand that Mr. Kenneth is not a whole lot of heads up. It is a heads up as it relates to him making that potential motion as opposed to simply making it at the conclusion of the examination. So I am going to bind over. I do believe that the prosecution has met their burden to establish by a probable cause standard. That's the standard here. Probable cause standard, crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes. There is a question of fact that remains here that needs to be determined by the fact finder. That is what the burden is at this phase. It is not a trial here today. The burden of proof will rise substantially once this matter proceeds to a higher court, and that is going to be beyond a reasonable doubt, will be the burden that I'm certain Mr. Kenneth will hold the prosecution to that much higher standard. The matter is going to be bound over on a total of 5 counts of criminal sexual conduct, 3rd degree, force or coercion, penis to mouth, and count, that would be 6, criminal sexual conduct, 3rd degree, force or coercion. And, well, I guess in order to make as clean of a situation here as possible, what I'm going to indicate is that counts 1, 2, and 3 will be bound over as charged. The misdemeanor is going to go along for the efficient administration of justice. And then 4, 5, 6, and 7 will be added as the criminal sexual conduct, 3rd degree, force or coercion, penis to mouth. So those 4 additional counts are being added onto the bind over, but as counts 4, 5, 6, and 7, as opposed to what I started out saying. The AOI date, the arraignment on information date, is going to be the 12th, August 12th.
Your Honor, the people do need to address bond as well.
Okay. Okay, please proceed.
I'm going to actually call the complainant witness back into the. Officer, he's going to use there.
There's one else.
Did I talk to you already this morning? Okay, you have the in-person exam tomorrow, right? Okay, what do you need to know? They're trying to limit the number of people in the hallway, so unless she's subpoenaed, probably no. I mean, is there social extenuating circumstances? Usually no. The social distancing and the local limiting.
Yes, Judge. Ms. Harris, have you been contacted by anyone related to Mr. Popper regarding this case?
Yes,
Okay, and who was it that contacted?
it was his mother, Carolyn.
Okay, and is this someone you had spoken to before this? So did you recognize the phone number?
Yes, I had been talking to her for a long time.
Okay, so when did she contact you about this case?
She contacted me on Monday, August 2nd.
Okay, and was that by phone call or text message or how was that?
It was via text.
Okay, and what did she say to you? And I'm gonna ask that the witness just go ahead and, well, do we need, well, she's still sworn in, I suppose.
You are still under oath.
Okay, so if you go ahead and just read what she texted to you.
Yes, she asked me if, she said, he goes to court the 5th for your charges, right? And I responded, I don't know when he goes to court. I try not to think about anything. And I'm trying to give my mom legal authorization on behalf unless in situations I have to be present. She was like, okay, but will you have to have representation at the court hearing? And I was like, I believe that will be Blake Eaton. No one has reached out, but I'll tell my mom now, I'm at her house actually. She hasn't left me alone yet.
Okay, and this next text from her, what did she say?
She said, yes, do that because Troy was trying to get me to get you not to show up, probably so he gets a lesser charge or walks, whatever the reason. I know it has to be for his benefit, so that's not a good sign.
Okay, so, my understanding is after speaking with the mother related that the defendant had contacted her and asked her to try and get Ms. Harris to not show up to court. So I would argue that is a violation of the order against indirect contact. At this time, the people would move to amend the bond to remove the 10% provision. I believe it's currently a $50,000 10% provision, and the people would move to have the bond amended to $50,000 cash or surety based on this violation.
Mr. Kenneth?
Your Honor, in speaking with my client, he indicates he did not ask anyone to contact the complainant on his behalf. This is his mother who has apparently reached out, although I would ask that those messages be saved and all of that information because that may be relevant down the road in some further discussion on this matter as to whether that is the, I don't know what number it came from. Somebody could put it in the phone to say Carolyn, Troy's mom, whatever, but it could be anybody's number. It could be your number, it could be the clerk's number. You assign the contact information. So having the number, what it actually is, and being able to relate that, but there's still, even if you connect that to Carolyn, there is no connection between my client and his mom. And there anything there other than an alleged text message saying that he tried to contact her. And if this is his mom and he's contacting her to reach out to the complainant, she's telling the complainant, this doesn't sound right. We're just asking the bond to be left as it is. Mr. Hawford has indicated he has not tried to reach out to anyone. He is not going to try to reach out to anyone. He understands that he can have no contact, whether it's through mom, siblings, friends, the court, myself. Like, there's no contact about this case with the complainant. He understands.
So, Mr. Poppert, it is really important that you understand, and anyone that you may communicate with or that might be listening on YouTube that is in relation to you, that no contact provision is really, really serious and really important. And no contact includes not only direct contact, but indirect contact as well. No chat, no text, no form of social media outreach, and you can't even have an individual acting on your behalf to reach out to the complaining witness. There's no backdoor way of accomplishing that. And the court treats any violation to that degree very seriously. Even though you are in custody, prosecution is now asking for your bond to be amended, increased in fact, or the 10% provision to be removed because of this violation. And there is no, it doesn't sound like there's much of a dispute that this did occur. But anytime you have a situation where a witness potentially is feeling threatened or coerced to not appear in court, that's a really big deal. And I'm not comfortable with the posture that has been, that we're at right now. And I'm not going to remain on the, with the 10% provision. Can I have a bond form, a bond amendment form? The bond is going to be amended to eliminate the 10% provision. Bond is $50,000 cash assurity with GPS tether and all of the other conditions that were put in place before.
And Your Honor, would the court prefer the matter so that we can review the bond at the
Yes.
circuit court level?
Yes.
Thank you, Your Honor.
You're all set for witness, what's it called?
Yes, thank you. Well, one moment.
We're all set. Finish this first. Yeah.
Have a good day, Your Honor.
You too. You too, Mr. Konecki. Mr. Glovers, don't forget, I will need your signature on this.
Yes, Judge, I will be right back.
Wait, what? Wait, I'm confused. I thought she said that she didn't have witnesses.
No, I don't think she just was going by.
Hi, Tammy.
Mr. Cripps, I know you've been at exam, but have you heard from Mr. Makepeace? I don't believe he's ever checked in this morning.
I just sent him a text asking him to zoom in right now.
Okay.
Says he's on. He says he's on the court record in circuit court, and he'll join us when he can.
Okay. Here's Mr. Strong. Judge, I can only send an email to Ms. Cal, so
Then please instruct her to zoom in tomorrow. Tell her she must zoom in tomorrow,
do you want me to?
or this afternoon. But she, yeah, it needs. Well, again, have we received confirmation? I guess I don't want to recall it if we don't know for sure that it's Clark and what was the other person's name? Christian, Clark and Christian.
So after speaking with, APA Bailey, she did say
We're not on
that.
the record yet, though.
Oh, okay. I guess there was she had officers for Clark, but the Christian matter was gonna get dismissed. But she could have proceeded on Clark, is what she said.
Okay.
So Mr. Strong's case is fine then. He was on
Clark though.
Are you on Mr. Clark or are you on Christian, Mr. Strong?
Your Honor, both of those are co-defendants. And basically, the police report indicated that there was an alleged felonious assault. Police arrested Mr. Clark and arrested Mr. Christian. Mr. Christian was charged with felony firearm and felonious assault. While in the police car being transported to the detention center, police officers allegedly noticed Mr. Clark moving around in the back seat. And when they got him out of the car, they found cocaine. So he was charged with 3 counts, FA, FF, and possession of cocaine. That's why they were able to proceed with the officers as it relates to Mr. Clark on the possession of cocaine charge, not as to the FA and the FF.
Okay, so can I trouble you for that file back? I'm sorry.
Yeah, I'm just trying to get,
I still don't know who these represent.
Yeah.
I represent Mr. Christian. Ms. Cal
Oh.
represents Mr. Clark.
Okay. Okay, recalling People versus Willie Clark and Marcellus Christian, 200-58372. I do understand that Mr. Christian is not here, nor is his attorney, Ms. Cal. But it should be noted, these are co-defendants, and I certainly hate to have a confusing or a sloppy record. So I'm a little bit frustrated, and I want to make sure that we perfect this record. Just before appearances are put on, let me just state procedurally what has happened. This matter was set, both Clark and Christian, for an examination yesterday. Neither Christian nor Clark appeared. Both Ms. Cal on Zoom and Mr. Strong in person appeared. And I indicated that KPSs were going to issue. However, I would hold it in the event that you were able to get your respective clients, I know I'm speaking really just to Mr. Strong right now, to Zoom in later that afternoon. Mr. Strong did in fact Zoom in later that afternoon with his client, Mr. Willie Clark, who I believe is present in the Zoom gallery right now. And we were enthralled in another examination. So we had to continue with where we were, and we weren't able to address it yesterday afternoon. I asked Mr. Strong and Mr. Clark to kindly Zoom in this morning, which they did. And it was my understanding that I thought I had asked specifically if there were witnesses present. And I thought that the representation was that there were no witnesses, which, as a courtesy, because Mr. Strong had availed his client by way of Zoom, even though he should have been in person yesterday, I allowed Mr. Strong to make the motion for a dismissal, seeing as though it was my understanding that witnesses had not appeared for the examination date. I did the same courtesy for Mr. Christian, who's represented by Ms. Cal. We'll take that up when Ms. Cal joins us. If not this morning, we'll set it for a hearing tomorrow. And hopefully she can have her client appear as well, as there has been some changes. It's my understanding now that there were witnesses here, and I'm a little confused, so I'm gonna toss it over. I'm gonna first ask for appearances to be placed on the record. Mr. Willie Clark, can you put a shirt on, please? I'm gonna ask for appearances to be put on, and then Madam Prosecutor to explain what, so we can have a clear record as to which witnesses came for who, and what are we doing here?
Okay. Remax Fufi on behalf of the people.
Mr. Strong?
Yes, Your Honor. Ronnie Strong appearing on behalf of Mr. Christian, and Ms. Cal is representing Mr. Clark.
Oh, I'm sorry. I misspoke. Mr. Christian, I needed you to put a shirt on. Thank you. Mr. Christian, please state your name. Please. Unmute, please.
This is Mr. Clark, ma'am.
Oh.
Yeah, I don't know.
Oh, okay.
Okay, so.
Okay, this is Mr. Clark,
Yes, ma'am.
represented by Ms. Cal.
Who is not here.
Where's Mr. Christian?
Your Honor, I just
He
talked
just
to
told
him.
me to zoom in. He just, I don't know. He just told me to zoom in.
All right, Mr. Clark, hold it for 1 second. Judge, I just spoke to Mr. Christian, and he's trying to zoom in now.
Okay, we're gonna pass on it because as confusing as this record has been, Mr. Christian needs to be made aware of what's going on, and it may still result, from what I'm hearing, in a dismissal for one of them, but not the other. But until we get this straight, I feel like I'm in muddy waters right now. So I want everyone who's possible to be present so we can clean this up and everybody understands what we're doing. Do you
Your
mind
Honor,
if you?
Mr.
Yeah.
Christian is in the waiting room.
Oh.
And Your Honor, as to Mr. Christian, his matter can be disposed of right now. The witnesses in question were witnesses as it relates to Mr. Clark, and it relates to the possession of cocaine charge. Those are the witnesses
I
that.
understand that, but I need the prosecutor to say that because I thought we had said this earlier and now I'm feeling confused. And I don't want to make any assumptions. I want the prosecutor to represent whether or not they're witnesses and on which defendant.
Okay, here it goes, Judge. So on Mr. Christian, we did not have witnesses. And that case was dismissed and we don't need to address it any further.
Okay, so as it relates to Marcellus Christian, who's still trying to connect to audio, Mr. Strong, that's your client. We don't need any further action taken on that matter as it was properly dismissed.
Yes, Your Honor. I'm not ready to leave.
And I thank you for zooming back in.
All right, Judge, have a good day. Be safe now.
Oh, you know what, Mr. Strong, do you know how to reach Miss Cal?
I do not, Your Honor.
I just reached her. I just tried to text her and tell her to zoom in, but I don't know. She didn't respond.
Okay. So, Mr.
Judge,
Clark,
if you want me to stand in for, I'll do it, and then she can be notified later about what happened.
Okay. I appreciate that. So, the co-defendant, Mr. Willie Clark, please state your name.
Willie Clark, Your Honor.
Okay, and Mr. Strong, thank you so much for standing in for Ms. Cal, who's his attorney. The confusion that was had, Mr. Clark, is that when I asked if there were witnesses here, I believed that the representation was there were no witnesses present yesterday for the scheduled exam. As such, I allowed your attorney, Ms. Cal, to make a motion to dismiss as a courtesy because you had zoomed in. And it comes to light now that there were witnesses as it relates to the charges against you, which were distinct from the charges against Mr. Christian. So that changes the dismissal. Is that true, that there were witnesses here as it relates to Mr. Clark.
That is true, Your Honor. There were witnesses here for Mr. Clark.
So the dismissal that was placed on the record some 20 minutes ago is now set aside, and we are back to square one. The matter needs to be set for an examination, an in-person examination. I'm not going to penalize you for not appearing yesterday, but I'm also not going to dismiss it because there were witnesses with regards to your charges. So we need an in-person examination date.
Your Honor, if I may, on behalf of Mr. Clark, standing there for his attorney, Ms. Cal, Mr. Clark's submission, if the court is going to reinstate the charges against Mr. Clark, we would ask that only those charges that people were ready to proceed on be reinstated. And that would have been the possession of cocaine. As to the other two charges, the FA and the FF, they were not ready to proceed on that. And as to those charges, we would ask that those charges be dismissed.
Madam Prosecutor, I would think that would be an appropriate action to take if there were no witnesses as it relates to
those two charges.
Yeah, let's see.
I agree.
I'm going to say this. I don't want this record to be unclear, any more unclear than it is. I'm not familiar with this file to the extent that I'm involved with any strategy or which witnesses are needed for what. So I want this record to be very clear, Madam Prosecutor, what counts, because there are a number of counts here. I don't know what officers were going to what they were going to testify to. So I want you to state on the record, Madam Prosecutor, which counts remain against Mr. Clark.
Well, Judge, I would need to look at the file in that case to make a better judgment. I'm not ready to make that representation right now.
What I think we need to do then is set this for a, I don't want to do that. I want us to know right now, if that means Miss Bailey is going to have to zoom in, then so be it. I don't want this record to be any more muddled. So I'm going to hand the file over and see if we can, Mr. Clark, I need you to hang on. Mr. Yes, Christian, you're all set.
Your Honor, I have the information in front of me, and the only count that pertains to Mr. Clark is count 4.
And I understand that, but I need to hear that out of the mouth of the prosecutor.
Oh, Miss Bailey's in the waiting room.
Bailey? Hello?
Yes, Your Honor.
Put your appearance on, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Okay, so I don't know what you've been told or what you're aware of, but the representation that I had was that there were no witnesses, and that's why they both were dismissed. That being said, we're not going to rehash that. We're perfecting this now. There's no argument that needs to be made, so please don't go down that road. What I'm asking right now is which charges were there witnesses for which to proceed on for Mr. Clark? We're done with Mr. Christian because it's my understanding there were no witnesses for Mr. Christian.
That is correct, Your Honor. So for purposes of what we have going forward, Your Honor, counts 5 and 6 are to be dismissed without prejudice, leaving count 1, felon, possession by felon.
Wait, Ms. Bailey?
Yes, ma'am.
We're not talking about Christian right now. We're already done with Christian.
No, I know, Your Honor.
Please refrain your comments to Willie Clark.
Yes, Your Honor. Willie Clark is charged in count 1, possession by felon. Count 2.
Counts he has against him. I'm asking, what witnesses did you have for the counts that are against Mr. Clark?
Your Honor, I had Officer Tobel and the OIC Stephen Hyde yesterday.
As it relates to?
Willie Clark.
It
Counts
counts.
1, 2, 3, and 4.
Now, that is a very different representation than what we just heard. So that is why it's important that we understand that now there are 4 counts left for Mr. Willie Clark. Not just 1 count, not just count 4, 4 counts. Counts 1 through count 4.
Yes, Your Honor.
Mr. Strong is standing in for Ms. Cal. We're going to set this down for an in-person examination. If the date does not work for Ms. Cal, we are going to simply wait to hear and grant a new date. But as for now, Madam Clerk is going to assign a date, hopefully sometime in November, December. And the dismissal that was previously put on the record about 20, 30 minutes ago relating to Mr. Clark is set aside. The charges are formally reinstated, counts 1 through count 4, because there was a witness or there were witnesses present. And you were not here, but I was allowing your attorney to make the motion to dismiss because you zoomed in. But that's now being cast aside, and we're putting this back on track as opposed to issuing a warrant because you failed to appear. And we're gonna set this for an in-person exam.
Judge, we can do on Tuesday, November 30th at 11 a.m.
Okay, and in the event that is a date that does not work for your attorney, we will simply reconfigure the date when we hear from her if that doesn't work. But otherwise, it's going to be on our calendar for November 30th at 11 a.m. Now, it's important. I don't know what caused you not to be here yesterday. You need to put it on your calendar.
Yes, ma'am.
You need to be present, not on Zoom, but in the courthouse
Yes, ma'am.
at 11 a.m. And I would plan to arrive well before that, as there still will likely be a health screening that you need to go through, as well as the regular security protocols. Okay?
Yes, ma'am.
Anything further in this matter?
Nothing
Your Honor,
further from the people.
Your Honor, Ms. Cal will be notified by the court of the date.
Yes, sir. I will.
Okay. All right. Nothing else done by the defense, Your Honor.
Thank you so much.
All right. Thank you, Your Honor. Be safe.
Calling parties on Williams. Case number 2062039, the people of the state of Michigan versus Anthony Jamar Williams. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons carried concealed. Count 3, weapons, felony firearm, habitual offender, 4th offense notice. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Kmac speaking on behalf of the people.
Good morning, Your Honor. May I please assign a report Jermaine apply with my P number is 54352 on behalf of Mr. Williams, who is behind me to the right.
Please state your name.
Anthony Williams.
Thank you. Are we proceeding to an examination?
Your Honor, at this time, the people are not ready to proceed. Trooper Jake Yaquan was subpoenaed and notified to show up to court today. And has not done so.
Consequently, Your Honor, we will make the motion to dismiss.
This matter was set for an examination at 11 a.m. It's currently 12:05, and with the representation that's been made, I am going to grant that motion to dismiss this matter. The matter is going to be dismissed without prejudice, which means it is possible for the prosecutor to reissue. You understand that, sir?
Yes.
Okay, if you have questions about that, please make sure you consult with your attorney and he will explain it to you in greater detail. Do you have on a GPS tether?
No.
Okay. Mr. Wyrick, I need your signature on this order of dismissal as the moving party, and we're all set.
Thank you very much, Your Honor.
Thank you.
Thank you for your time. Can I do a quick introduction, Your Honor? This is my intern, Jessica Kramer.
Oh,
She's a
fantastic.
student
Come on
at
up.
Harris State University. Her last week with me, though, I'm gonna miss her. She's going back to school.
Oh, come up to the, no, come to the podium.
Right there.
Yeah, come around. Now tell me, what is your name?
Jessica Kramer.
And what's your story?
I go to Ferris State University. I'm going to be a senior this year and I'm a criminal justice student.
Wait, oh, so you go to Ferris?
Yeah.
And you're gonna, and so you wanna go to law school eventually?
Yeah, I'm going to take the LSAT in January, I
Oh,
think.
that's exciting.
Yeah.
What else?
What else do you want to know?
Well, I'm certain that you've had an opportunity to gain quite a bit of it. Well, this is a weird time to be shadowing someone, isn't it?
Yeah.
During a pandemic, probably the best time though.
I've been keeping her busy. She comes to work early, meets me there, you know, wonderful young lady.
Well, but it is, you know, you never know. I mean, who knew that we would ever be in a circumstance like we are with the pandemic? And being able to navigate through this.
Yeah.
And basically have like a mobile office. You know, because you're always, you have to be in multiple courts as a defense attorney. You have to be in multiple Zoom courts at the same time, and being able to juggle all of that. I think probably this has been very eye-opening for you to see it from this perspective.
Oh, 100%. We don't go in person that often, actually, so a lot of it is, you know, I actually live stream the Zooms. I don't go into the Zooms, but I watch them all, because then people ask, what are you doing in here? Because I go in under like his name and stuff.
Right.
But I've got to see a lot of different types of court cases, see a lot of different types of people. It's definitely different than going in person, but more recently we've been able to go in. We were in East Point the other day.
Oh, okay, so you've been around to different courts.
Yeah.
Well, you know, I always tell young attorneys, or those interested in law, take time to do exactly what you're doing. Exposing yourself to different courtrooms, different types of law, because there's so much you can do with a law degree. And it's important to try to figure that out before, you know, you're charged with this, you know, all that responsibility of marching into the legal field. It's a good idea to kind of know the direction you want to take with it. And the best way to do that is by following, shadowing, interning, and getting a real bird's eye view of what type of atmosphere you're going to be in, because, you know, it's not for everyone.
Right.
You know, this sort of law is being in a courtroom like this, it's not really for everyone. But I think those of us that are here, we're very passionate about it. But, you know, if you put us in a different setting, we may not be as inspired. And so it's important to figure that out, because trying to figure that out after you've got your P number and you're expected to start paying lots of bills, it's a difficult time to try to figure it out. So this is the time you do it. You're doing it well in advance because you haven't taken the LSAT yet, but this is when you do it. This is when you figure out what you're made of and what's going to inspire you, because I tell you, once you get out there, you know, you want to do something that you're passionate about, because that's the sort of job that you're going to want to get to work early for, like he said, and stay later.
Mm-hmm.
And so all of the things that come with success, all of the accolades and whatever you deem to be, to fall in line with rising to the level of success, all of those things come naturally when you're thrust into the type of work that you really enjoy doing.
Yeah.
So I applaud you in taking this time. I know you could be spending your summer doing other things. Seems like everybody's out there living their best life on vacation every day.
Well, the week I had 3 hearings down here in the row, she was another beat, you honest.
Oh, see, well, you are living your best life. Okay,
I
you
still
need
need to do that.
balance, right? You need balance. Well, it's a pleasure to meet you.
Thank you.
I wish you the best. I love talking to students.
I
And-
think she's gonna be a prosecutor too.
Oh, yeah?
Yeah.
Okay, this kind of led me to where I wanted to go. I don't think I'd be a great defense attorney, if you want me to be entirely honest, but I really do love watching the prosecutors. And like, there was a prosecutor who worked in the domestic violence unit in Wayne, who I thought was really cool, so I kind of started looking into stuff like that. But
Well, if prosecution is what you're interested in, Mr. Wyrick knows a ton of people in that office, and there's one young lady behind you that does an outstanding job. Have you met Rima Yafupi?
No, I've seen you on the live streams, but I've never
You
met you.
need to take a moment and introduce yourself and ask, maybe get, I don't know, do you have cards anymore? Do prosecutors have cards? Give her your card or?
I forget to bring them because, you know, we're still in shutdown mode.
Yeah, but you know, anybody that you meet in the midst of observing and whatnot, everybody's a potential contact for something you may want to branch out into in the future. This young man here. Wait, are you an intern or are you with the office?
He's about to get his P number.
Oh,
I just got hired, Your Honor. I was, I mean, you can relay to her that it doesn't pay that well.
Wait, what did you say? It doesn't. What did you say? It doesn't.
On that. Yeah.
Wait, okay, I couldn't really hear you. Did you say it doesn't pay well?
I said, yeah, if you just want to relay the message to her, that it doesn't pay very well to be a prosecutor.
Oh, however,
Sure.
it all depends on how you look at it.
Sure.
Because the experience is priceless.
I'm just kidding.
And the experience by way of.
And I would interject, I was congratulating one of your new colleagues this morning who became criminal prosecutor.
Yeah, I mean, you know, the getting that foundation and being in court every day is really priceless. And so that, you know, that should translate to wherever you go. You know, this is a side note. Both things are important, to be passionate and to be compensated. But there is an aspect of paying your dues and getting in there and having some sort of foundation for which to write your own ticket. So.
One thing that was super great about this summer is that any courtroom that we've gone into, you've introduced me to the judge or the prosecutor or anybody. Like I've been meeting people, even though all of the masks and the COVID
and so
all
what's,
of that stuff.
What's your name again?
Jessica
what?
Kramer.
Jessica Kramer. She's the future. Just giving you a shout out on YouTube there. All right, okay, do we have anything else ready while we're?
Thanks, Jess. Have a great day.
Take care. Good to see you.
I don't think we have one is Mr. Cripps, Mr. Isaac. I see he signed on. Oh, he did. I haven't heard anything back from the chief yet.
Oh, wow.
All right. I did, I think that I copied you and Judge Archer on the updated version of the motion, just as an FYI, in case anyone from the Chief Judge's court contacted you. So we'll be standing by. I'll update Ms. Clark Woodside.
I'll try to check in with them this afternoon. I can run up there and check in with them and see what action is going on with it.
All right, sounds good. And as always, we're standing by for anything that you might need.
Okay, thank you.
Thank you, Mr. Isaac.
Thank you.
Or good afternoon.
Hello.
Hello. We've been seeing you every day, Mr. Perlman. Do you miss us or?
I can't, a day can't go by without seeing you.
What are you here for today?
Okay, so, Ms. Heath is here. We're gonna get an adjourned date for Xavier Lewis to move it up.
Oh, right, and Ms. Heath is here. Thank you, Ms. Heath, for joining us.
And then real quick, Ms. Shafufi,
Yes.
do you think you can stand in for Mr. Maker?
Good afternoon.
Just a moment, it's just getting another date.
Okay.
They didn't get the,
What case is that?
competency hearing back, competency report back. So I'm gonna do this one and then we'll go to that one. Calling parties on Lewis, case number 2057667. The people of the state of Michigan versus Xavier Lamar Lewis. The defendant is charged with count 1 and 2, criminal sexual conduct, first degree during felony, SORA notice, HIV STD testing notice, count 3 and 4, criminal sexual conduct, third degree force or coercion, SORA notice, HIV STD testing notice, count 5, home invasion, first degree, count 6, motor vehicle, unlawful driving away, habitual offender, second offense notice. This is scheduled for, we're gonna move the date up.
Okay. Appearances, please.
Good morning, Your Honor.
Good afternoon. Kelsey Heath on behalf of the people, P83350.
Good afternoon, Your Honor. Jeff Perlman on behalf of Xavier Lewis, P80517.
And Mr. Lewis is not here. Are you comfortable waiving his presence for purposes of moving his exam date closer?
Yes, Your Honor.
Okay, so ordered. Yeah, so after we left the record the other day, it dawned on us, we hadn't talked much about the future date, and the future date not being until September 21st, now that he is in custody, certainly I wanted to give you an opportunity to request a much closer date. Is that what you would like, Mr. Perlman?
Yes, Your Honor.
Okay, so as you know, we're kind of spilling over here, but if you select a date, we will give you priority as much as we can. If you select a date that's, how much time would you say you'd need? At least 7 days, Madam Prosecutor?
I would say maybe at least a week and a half so I can do the subpoenas, give Mr. Pullman the discovery on the new case and everything as well. I will just note for the record, the new case that's attached to this, the PCC is on August 20th. But I would like at least a week and a half if we're going to move it up.
Okay. I had suggested August 13th. That's around a week and a half. Would that work for you?
Madam Prosecutor, would that work for you?
Your Honor, I do have a bench trial in front of Judge Bozzi here in Third Circuit that day at 1:30. So I would be willing to do an exam in the morning. It's just that we would have to be done with the exam at 1 o'clock. And I think it is going to be a rather involved exam.
How many witnesses do you believe?
Ms. Heath?
Sorry, I apologize. I was on mute. Possibly 2 to 3.
I don't think that the 13th will work. I'd hate to have you get here and then we certainly could start it, but I don't think we'd be able to finish a 3-witness exam with our busy mornings.
Now, would the afternoon work at all? Or on any given day?
We typically have homicide exams at 1:30, but let's see if we can find something that's non-custodial that's happens to be there.
I mean, I could, looking at August 19th.
I said, we didn't even have you guys hearing till 1.
Or even August 20th.
The 19th and 20th would work for me as well. And as I mentioned, the PCC for Mr. Lewis on the new case is also already scheduled for the 20th.
Okay, so maybe let's put it, can we put
At what time? If they're wanting an afternoon, I'm just,
we are not have, we can do
Okay,
that
so what
after.
did you say was this?
What about,
I mean, once we start, I guess that will just take precedence over.
yeah, so maybe if we started earlier as opposed to later.
Started at 10?
10 o'clock, could you do 10 o'clock on August 20th?
I have I have a hearing at 10 o'clock. I could do it at 11 o'clock. I do have a in-person exam at 12, which I could probably move.
Okay. All right, we'll call for
It was
and figure out
before Judge,
they're dealing.
originally before Judge Giles.
So are you
But
saying yes, 20th
Yes.
or no?
Yes, the 20th will work.
At 10 o'clock?
Okay, let me.
Yes.
Call the court and when I get a.
Oh, no, I'm sorry, 11 o'clock, 11 o'clock, please.
11 o'clock.
Yeah, we'll just probably have to do it bifurcated.
August 20th at 11 o'clock in the morning, in person.
Yes.
Thank you.
Thank you.
Thank you, Judge.
Yeah.
Okay, be well.
You too. Said Mr. Makepeace is not here.
Yeah, and Judge is just getting another hearing date, so I don't know, Ms. Yafuki, were you comfortable standing in on that for him?
Yeah.
Calling parties on board. Case number 2157423, The people of the city.
To today's hearing, your staff was so kind enough to send your Cobb's evaluation over.
Is that Mr. Cruz?
Yes, Your Honor, I'm here. My other Zoom is muted now.
Mr. Cripps, Ms. Shafuzzi is just gonna stand in. We're just needing to select another date for the comp hearing, correct?
Correct.
Okay. Calling case number 2157433, the people of the state of Michigan versus Gerard Antonio Ward. The defendant is charged with count 1, homicide, murder, first degree premeditated. Count 2, homicide, felony murder. Count 3, weapons, felony firearm, second offense notice. Count 4, robbery, armed, serious injury. Count 5, weapons, felony firearm, second offense notice. Count 6, weapons, firearms, possession by felon. Count 7, weapons, felony firearms, second offense notice. Habitual offender, fourth offense notice, mandatory 25-year sentence. Judge, this is scheduled for a competency hearing.
Thank you. Appearances, please.
Good afternoon, Your Honor. Read my affidavit on behalf of the people.
Good afternoon, Judge David Cripps, P 34972, appearing on behalf of Mr. Gerard Antonio Ward. I would waive his appearance. He's currently at the Wayne County Jail.
So ordered. Okay, so we do not have a report back yet. Is that my understanding?
I have a letter, Judge, dated July 30th, 2021 from Dr. Ann Zaborni from the Center for Forensic Psychiatry. In part, it reads, quote, "This is to advise the court that my reports on competency to stand trial, criminal responsibility, competency to waive Miranda will be delayed and were not completed within the 60 days specified in the court order." She says the completion will be done in about 3 to 4 weeks. So I'm asking for a continuance to allow the doctor to complete her report.
All right, so today is the 5th. Do you want to set it for like the second week in September?
That makes sense to me.
September 9th?
That's fine for the defense.
All right. New competency review, etc., set for September 9th at 8:30 via Zoom. Okay, all right, anything further?
Not on behalf of the defense, Judge. Thank you.
Okay, thank you.
And I'll email Mr. Makepeace.
Thank you for standing in.
Thank you, Mr. Cripps.
Thank you.
Okay.
Everybody have a great day.
You too, be safe.
Thank you. You too, Judge.